Hi, I'm Matthew Piccolo, an attorney licensed in Nevada and Utah. In this video, I'll explain 12 ways an employee can be wrongfully terminated in Nevada. Getting fired from a job can be a difficult, demoralizing experience. It can also be harmful to your economic and emotional well-being. It's not surprising then that many people contact an employment law attorney like me for help. Unfortunately, in most cases, I can't do anything to help because what the employer has done might be unfair, but it isn't wrongful termination, meaning an unlawful termination. So what is wrongful termination? To explain what an unlawful termination is, it's easiest to begin by explaining what is lawful. You've probably heard that Nevada is an at-will state. At-will employment simply means that, in general, your employer can fire you at any time for any reason it wants. I say in general because there are a lot of exceptions to the default rule of at-will employment. As long as your employer doesn't violate one of these exceptions, it hasn't terminated you illegally. Let's go through 12 common reasons a termination can be unlawful. Exception number 1, contracts. Most employees don't have a contract. You do have a contract if you're covered by a collective bargaining agreement as a member of a union, or you might have signed an individual contract to work on a specific project for a specific length of time or have some other type of contract. There could also be an oral contract if your boss says things like, "I'd never fire you unless you really messed up," or "I promise you can keep your job for at least 2 years." The other way to have a contract is if your employer's handbook or other documents make promises about how long you can work, what it takes to fire you, or the disciplinary process. Outside of these situations, though, which aren't all that common, you probably don't have a contract. If you do have a contract, then a termination is illegal if your employer doesn't follow the terms of the contract. Exception number 2, discrimination. Your employer can't discriminate against you in any way based on a protected class, such as race, religion, disability, age, or sex. Federal and state laws prohibit this type of discrimination, and it is serious. If your employer discriminates against you based on something else, like your boss doesn't like your personality, then it might be unfair, but it isn't unlawful. Exception number 3, retaliation. Your employer can't retaliate against you when you do certain things. I'll list 10 of the most common things. 1, whistleblowing, reporting illegal conduct by your employer like health and safety violations or fraud to a government authority. Reporting inside the company isn't enough. You must report it to an agency outside the company. 2, unsafe conduct, refusing to work under conditions that are unsafe. Unsafe means conditions that are unreasonably dangerous to you. 3, illegal conduct, refusing to do something your employer wants you to do that is illegal. 4, workers' compensation, filing for workers' compensation, then you're terminated. 5, jury duty, taking time off for jury duty and you're terminated. 6, FMLA, taking time off under the Family Medical Leave Act. 7, concerted activity, taking action to improve your pay and working conditions, whether with a union or without. 8, legal product, using a legal product off duty, such as alcohol or firearms. 9, complaint, filing a complaint involving employment discrimination with the EEOC or NERC, or a complaint involving wages or hours of work with a government agency or internally. 10, investigation, participating as a witness or in other ways in an investigation involving employment discrimination, wages, or hours of work. If your employer fires you, demotes you, or retaliates against you in any way after you do one of these 10 things, then you might have a case for wrongful termination. If the retaliation was because of something else, then more than likely you don't have a case. Now, what if your employer makes a false accusation against you? Your employer might mistakenly suspect you've done something wrong or even blatantly accuse you of doing something wrong, knowing you didn't do it. But in most cases, a false accusation isn't unlawful. If the accusation really ends up damaging your reputation or career, then you might have a case of defamation. In the end, employers do a lot of things that might truly be unfair, immoral, even unethical, but just because it's one of those things doesn't mean it's necessarily unlawful. If what your employer has done does fit within one of the 12 exceptions to at-will employment we've discussed, then there is a chance that you have a case for wrongful termination. Well, that's it for this video. Thanks for watching. Contact me if you have questions. My website is piccololawoffices.com. Thanks for watching.